the trademark that exposed a billion-dollar slush fund, and the agency that helped hide it. The United States Patent and Trademark Office has 9 trademarks. 4 are logos for the office itself. 3 are phrases from a public awareness campaign about consumer protection. And 2, the newest 2, filed this year, belong to something called the Board of Peace, an entity that has no verified corporate structure, no registered address in any country, no public audit mechanism, and no congressional appropriation. An entity whose bank accounts exist in locations that no one in Congress has been able to identify. An entity whose chairman for life is the sitting president of the United States. The agency responsible for regulating trademark law just filed trademark applications on behalf of that entity. Jamie Raskin walked into that hearing room with 9 pieces of paper, 1 for each of the USPTO's trademarks. He laid them on the table in order. The first 7 were unremarkable: government logos, consumer protection slogans, the kind of institutional paperwork that accumulates over decades of normal agency operation. Then he laid down the last 2. The room understood immediately what it was looking at. The Board of Peace trademark applications were not filed by the Board of Peace. They were filed by the United States Patent and Trademark Office itself, the agency that is supposed to be the neutral arbiter of trademark disputes, the institution that adjudicates who owns what name and what logo and what commercial identity in the American marketplace. That agency had decided to stand in as the applicant, to hold the trademark, to become, in language of the law, the registered owner of the intellectual property associated with a private multi-billion-dollar fund controlled by the president. Director Squires was at the witness table when Raskin put those papers down. She didn't look away. That detail matters. People look away when they don't have an answer. She looked at the documents, both hands flat on the table in front of her, posture straight, the particular stillness of someone who has rehearsed their composure, with the specific expression of someone who's already decided that her answer is going to be whatever it needs to be, and is preparing to deliver it in a register that sounds more like institutional procedure than personal decision. It was, she would say, a process matter. That phrase, a process matter, is the institutional equivalent of a hand raised to stop a question before it completes. It sounds like an answer. It has the grammar of an explanation, but it contains no information about why the USPTO specifically was chosen to hold the trademark, or who made that decision, or what conversations preceded it, or whether the legal implications of the filing were analyzed before the applications were submitted. Process matters are how institutions describe decisions they don't want to call decisions. Raskin let that hang in the room for exactly the right amount of time. Then he started with the law, the Lanham Act. The federal statute that governs trademark registration in the United States was not designed for this. Its language is specific. Only a person with a bona fide intention, under circumstances showing good faith, to use a trademark in commerce may request its registration, not a government agency filing on behalf of a private fund, not an institution standing in as a straw holder to shield the actual controlling entity from the disclosure requirements that trademark registration normally produces. The Lanham Act was not written to accommodate the scenario in which the agency charged with administering trademark law files applications for an organization that the agency has no organizational relationship to whatsoever. Raskin said that clearly. The agency whose role it is to administer and police the registration of trademarks had just filed applications for an entity that has no connection to the USPTO in a process that requires the applicant to identify the legal entity that controls the mark. And the USPTO had stepped in to prevent that identification from happening. The bona fide intention requirement exists precisely to prevent this. The Lanham Act requires that trademark applicants have a genuine intention to use the mark in commerce, a requirement that forces the actual commercial actor to step forward and identify itself. By substituting itself as the applicant, the USPTO removed that requirement. The entity that actually controls the Board of Peace, whose identity, corporate structure, and banking arrangements are the central unanswered questions before Congress, was never required to appear in the trademark application at all. The USPTO's name is on the filing. The Board of Peace's controlling entity remains unnamed. The trademark application, in other words, was covering something up. What it was covering up is the question that the rest of the hearing was designed to answer. The Board of Peace is not a well-understood entity. That is not a characterization. That is the documented reality, confirmed by the absence of basic corporate information that any legitimate organization of its stated size and scope would be required to have publicly available. Raskin laid out what Congress does not know about the Board of Peace. The list was longer than anyone in that room expected. No verified corporate structure, not a summary, not a high-level description, no structure at all that Congress has been able to confirm exists in any documented form. A billion-dollar entity with foreign sovereign partners and a self-declared permanent chairman does not have a publicly identifiable governance structure. That is not an oversight. That is an architecture. No registered entity in any country. The Board of Peace has not been incorporated in the United States. It has not registered as a foreign entity operating in the United States. It does not appear in the corporate registries of any of the countries whose governments have committed billions of dollars to it. It exists as a name, a trademark application, a set of press releases, and a promise of billions of dollars in taxpayer funds that Congress never voted to appropriate. In every country that receives foreign investment, there are registration requirements, disclosure requirements, legal obligations that attach to any entity accepting sovereign wealth. The Board of Peace appears to have satisfied none of them in any country, in any jurisdiction. No identifiable bank accounts. The billions of dollars committed to the Board of Peace from the United States Treasury and from the foreign governments whose names Raskin read into the record one by one have to go somewhere, into accounts, in institutions, in countries. None of that information is publicly available. None of it has been provided to Congress. The money is moving. No one in the legislative branch can confirm where. That is not a reporting delay. That is a structural feature of an entity designed to move money without producing the paper trail that normal financial architecture requires. No audit mechanism, no oversight structure, no independent entity that has been designated to review how the funds are spent, who controls them, or what happens to them after the Board of Peace's chairman for life decides what they're for. This record is open. What Congress was able to establish in that hearing room. The absent structure, the unidentified accounts, the foreign commitments, the trademark that confessed what the fund is the starting point, not the conclusion. If you want to follow what gets produced when the follow-up requests are answered, or what stays buried when they aren't, this is the record to track. The written response about historical precedent is pending. The corporate structure documentation is pending. The bank account disclosures are pending. The foreign contribution agreements are pending. Each of those pending items is a thread that either resolves or confirms what the trademark filing declared. This channel tracks the documentation as it moves, or as it stays still. The chairman for life is Donald Trump. That title appeared in the official communications about the Board of Peace. It was not given to him by Congress. It was not a designation created by any law or any vote. It is the title he assigned himself when he created the entity, chairman for life, of a multi-billion-dollar fund. With no corporate structure, no registered address, no identifiable bank accounts, no congressional appropriation. And now, a trademark filed by the federal agency that is supposed to regulate trademarks so that the actual controlling entity doesn't have to identify itself in the public record. Raskin looked at Squires. He said, by filing for a trademark, you're admitting that the Board of Peace is not really a governmental entity at all. It's a commercial enterprise set up by the president. She didn't dispute the legal logic. She couldn't. The Trademark Act of 1881 was written under the Commerce Clause. The modern version, the Lanham Act, explicitly applies only to marks used in interstate commerce. Section 1052B of that act specifically forbids the registration of any insignia of the United States government, any state, any municipality, any foreign nation, or any other governmental body. The prohibition is there for a reason. Governmental entities don't get trademarks because trademarks are tools of commerce, mechanisms for identifying commercial actors in a marketplace. When you file a trademark for something, you are declaring by law that the thing you're filing for is a commercial enterprise, not a government function. The USPTO had filed for the Board of Peace trademark. The USPTO had therefore declared in the permanent legal record that the Board of Peace is a commercial enterprise. A commercial enterprise controlled by the President of the United States, fed with billions of taxpayer dollars that Congress never appropriated, and billions more from foreign governments whose names read like a tour of the most legally fraught diplomatic relationships in American foreign policy. Raskin read them into the record. Saudi Arabia, Kazakhstan, Azerbaijan, the United Arab Emirates, Morocco, Bahrain, Qatar, Uzbekistan, Kuwait, 9 countries, billions of dollars, one chairman for life, no corporate structure Congress can find. Each name dropped into the hearing room with the weight of what it represented. A foreign sovereign government committing money to a privately controlled fund whose chairman is the sitting American president. A contribution that, depending on how the fund is structured and what the president does with it, may constitute an emolument The fund has no structure Congress can find. The president controls it. The contribution is billions of dollars. The emolument question answers itself. The Constitution has a word for this. 2 words, actually. The Foreign Emoluments Clause and the Domestic Emoluments Clause. Both of them prohibit the president from receiving payments from foreign governments and from receiving any payment beyond his official salary from any governmental source. The Foreign Emoluments Clause, Article I, Section 9, is direct. No person holding any office of profit or trust under the United States shall, without the consent of Congress, accept any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. The word emolument covers more than a gift. It covers any financial benefit received in connection with holding office. A foreign government committing billions of dollars to a fund controlled by the sitting president. A fund with no corporate structure, no independent oversight, and no congressional appropriation is precisely the kind of arrangement that clause was written to prevent. The Domestic Emoluments Clause adds that the president shall not receive any other emolument from the United States or any of them beyond his fixed compensation. Taxpayer funds flowing into a privately controlled fund whose chairman is the president implicate both clauses simultaneously. The Board of Peace, Raskin said, likely violates both. Squires had a response prepared. She reached for the papers in front of her, not the trademark sheets Raskin had placed on the table, her own materials, and delivered it without looking up. It was procedural. It referenced the applicable guidelines. It described the trademark filing as consistent with agency practice in certain circumstances. It used the language of institutional process, the kind of language that makes a decision sound like a form being filled out rather than a choice being made. Raskin let it finish. Then he laid out what the trademark filing actually meant for the USPTO's institutional independence. The USPTO administers disputes about trademarks. That is the core of its function. When 2 parties disagree about who owns a mark, or whether a mark infringes on another mark, or whether a mark should be canceled because it was improperly registered, the USPTO adjudicates those disputes. It is supposed to be the neutral arbiter, the institution that applies the law without regard to who the parties are or what political relationships they have. The neutrality is not optional. It is the foundation of the entire system. When parties invest resources in building a commercial identity under a trademark, they rely on the assurance that the institution managing disputes about that identity is not itself a party to those disputes. Every organization that has ever operated under a peace-related trademark, every nonprofit, advocacy group, educational institution, or international body that has built its identity around a word that the USPTO has now claimed on behalf of the Board of Peace, was operating under that assurance. The filing ended it. The USPTO now owns a Board of Peace trademark, which means that if any of the existing organizations whose names overlap with the Board of Peace, Greenpeace, the World Peace Network, the Global Peace Foundation, the Peace Trust, any of the dozens of organizations that have been operating under peace-adjacent trademarks for years, decides to challenge the Board of Peace trademark, the challenge goes to the USPTO, the institution that filed the trademark, the institution that is now the registered owner. The neutral arbiter is no longer neutral. It is a party. And it will have to rule on disputes involving its own trademark in matters that touch directly on the commercial interests of the President of the United States. That is not a hypothetical problem. It is a structural one built into the decision to file. The conflict cannot be managed by recusal because recusal would leave the USPTO unable to adjudicate any dispute involving the Board of Peace trademark. And that inability would itself be a form of protection for the trademark since no adjudication means no cancellation. The conflict cannot be resolved by transferring the trademark to another holder because the purpose of having the USPTO hold the trademark was precisely to avoid having the actual controlling entity appear in the public record. Every solution to the conflict the filing created requires either disclosing what the filing was designed to conceal or leaving the trademark in a state of permanent enforcement immunity. Raskin named it precisely. He said the field is crowded with existing registrations by other organizations: World Peace Table, World Peace Network, Project Peace, Peace Vision Global, Global Peace Initiative, Global Peace Foundation, International Peace Center, Peace Network, Peace Action, the Peace Trust. Any one of those organizations has a colorable argument that the Board of Peace trademark infringes on their prior registrations. Any of them could file a cancellation proceeding. That proceeding would go to the USPTO, which would have to rule as a neutral adjudicator on a dispute involving a trademark it owns, filed on behalf of a fund controlled by the sitting president. The structural conflict is total. It is not resolvable by recusal or internal procedure. The USPTO is both the applicant and the judge. That is the situation the Director Squires had created, or had allowed to be created, by agreeing to file those applications. And the person who made the decision to create that conflict is the same person who will have to manage it when the cancellation proceedings begin. Which, given the number of existing peace-related trademarks in the organizations that hold them, is a matter of when rather than whether. Squires said there were processes for managing conflicts of interest. The agency that files the trademark adjudicates the disputes about the trademark. That is not a process question. That is a structural impossibility. Raskin looked at the 9 trademark sheets on the table. He said, 2 of these are for an entity that has no organizational relationship to your office whatsoever. Can you identify any other instance in the history of the USPTO in which the agency has filed trademark applications on behalf of a third-party private entity? The room waited. Squires paused. A pause long enough that the stillness in the room became its own kind of answer. Then she looked down at her papers, not the trademark sheets, her own, and said she would have to review the historical record and provide a response in writing. That answer, the written response that removes the exchange from the room where it can be pressed and deposits it into a document pipeline where it can be delayed, is the sound of an institution that has been asked a question it cannot answer without consequences and has chosen the third option. Not yes, not no. Later. There is no historical precedent. That is why it takes time to find one. Raskin made a note. The written response would be followed up, but the question itself was already in the record, and the absence of an answer. The specific, documented on camera inability of the Director of the United States Patent and Trademark Office to identify a single historical precedent for filing trademark applications on behalf of a third-party private entity was also in the record. Next to the 9 trademark sheets, next to the list of 9 countries whose governments have committed billions to a fund with no corporate structure, next to the name of the chairman for life. Here's what the trademark filing revealed that the Board of Peace's architects did not intend to reveal. The act of filing was simultaneously an admission and a declaration. An admission that the Board of Peace is not a governmental entity, because governmental entities cannot register trademarks under the Lanham Act. And a declaration that it is a commercial enterprise operating in interstate commerce, controlled by the president, fed with foreign government money, and exempt from the disclosure requirements that any other applicant would face because the USPTO stepped in to hold the mark on its behalf. You cannot file a trademark without making a legal declaration about the nature of the thing you're filing for. That declaration is now in the permanent record. The trademark application was supposed to be a solution, a way to secure the Board of Peace's commercial identity without requiring the entity to identify itself publicly, without disclosing the corporate structure, without naming the bank accounts or the countries where they exist. It solved none of those problems. It created an evidentiary record that the filing itself was meant to prevent. It created a new one, because the act of filing for a trademark is itself a disclosure. Not the disclosure that was being avoided, the corporate structure, the bank accounts, the controlling entity, but a disclosure of a different, and in some ways, more consequential kind. A legal declaration entered into the permanent public record that the Board of Peace is a commercial enterprise, that it operates in commerce, that it is not a governmental body, that it is, in the statutory language that governs trademark registration, a person. A legal person with commercial interests that are being protected by the law designed to regulate commercial actors. A commercial actor controlled by the president. Raskin closed with a question that the trademark filing had made impossible to avoid. Not because the question was new. The emoluments clause concerns had been raised before the hearing. The absent corporate structure had been documented before the hearing. The foreign government commitments had been reported before the hearing. What the trademark filing added was the legal declaration, the permanent, irrevocable, statutory record, that the Board of Peace is a commercial enterprise. That declaration made every subsequent question about the fund structure, its banking, its foreign contributions, and its presidential control not just politically significant but legally actionable. The trademark application created the evidentiary foundation. Raskin was building on it. He said the president set up a board that likely violates both the foreign and domestic emoluments clauses, and now you're helping to run the operation. That's what the trademark filing means. You're not just a neutral agency processing a routine application. You're a participant. You're the registered owner of the commercial identity of a fund controlled by the president. You filed that application. Your name is on it. Your agency's name is on the mark. What did you think you were filing for? Squires said the agency had followed applicable procedures. Raskin gathered the 9 sheets. He stacked them slowly. The 4 USPTO logos, the 3 consumer protection phrases, and the 2 Board of Peace applications. He held up the stack and looked at it for a moment. Then he said, if the president can't win the Nobel Peace Prize, he'll just own the word peace instead. The room absorbed that. It landed not as rhetoric, but as description, as the specific, documentable outcome of a sequence of decisions that began with the creation of a fund with no corporate structure and ended with the federal agency responsible for regulating commercial identity filing trademark applications to protect the commercial identity of that fund. The word peace, trademarked, held by the USPTO on behalf of a chairman for life, funded by foreign sovereigns, exempt from the disclosures that any other commercial applicant would have to make. This record is not closed. The written response about historical precedent has not arrived. The corporate structure of the Board of Peace has not been produced. The bank account locations have not been disclosed. The foreign government contribution agreements have not been provided to Congress. The emoluments clause questions have not been resolved. Every one of those open threads is documented in the congressional record that this hearing produced, documented alongside the trademark applications that declared the Board of Peace a commercial enterprise and the agency director who could not identify a single precedent for what she had done. The open threads are not administrative loose ends. They are the questions whose answers would determine whether what the hearing documented is a procedural irregularity or something more consequential, where the money is, who controls it, whether the foreign contributions constitute emoluments, whether the taxpayer funds committed without congressional appropriation are being held, spent, or distributed in a way that any oversight mechanism can trace. Those are the questions that the trademark filing was designed to prevent from being asked. The hearing asked them anyway, and the written responses that haven't arrived are the documentary record of whether the institution responsible for the answers intends to provide them. If you want to follow where this documentation goes, what the written responses contain when they arrive, what the courts do with the emoluments clause arguments, what happens when any of the existing peace organizations files a cancellations proceeding against a trademark owned by the USPTO. This is the record to watch. The paper trail is not a metaphor here. It is a trademark application filed by the wrong party for the wrong entity under a law that makes the filing itself the evidence.